A very good morning to all the participants. On behalf of BCIC, we welcome you all for this exclusive session on will or settlement, an insight that's provided by Dr. KV Om Prakash, who is the advocate and founder director of Consentia Consultancy and who is also the chairman of our Corporate Economic Affairs and Legal Expert Committee. Thank you very much, sir, for making it convenient to address our members. The committee is co-chaired by Mr. Ram Prasad, who is the practice head, ASC and Associates, and mentored by Mr. Venkat Krishnan, who is the former advisor, Tata Hitachi Construction Machinery Company. Thank you, Mr. Vineet Verma, for making it convenient to join the session. Now, I would request Dr. KV Om Prakash to start his presentation. And before that, we acknowledge our member companies who are the annual sponsors of all the activities of the chamber, Messrs. Bueller, Fundromax, MTR, IAMPL, SDMIMD, Sona Group of Companies, TVS Motor, Vishwas Group, and Wipro. Thank you very much once again for joining this session. And now I would request Dr. Om Prakash to take it over from here. Over to you, sir.
Good morning, all. Happy morning. Thank you, Rupa, for this arranging this workshop. Today, we will be discussing on the different aspects of will and settlement. Many of you are aware what is will, what is the settlement deed, but there are some advantages, disadvantages in both of the conveyance. Both talks about property of the self-acquired property of the individual. In this webinar, I will concentrate on the finer parts of which is better than either of them. So I will be mainly concentrating as to the practical aspects. Today, we are into this COVID situation and many things have gone wrong. Many spouses have been put to surprise as to the what his husband or wife is doing, what are the saving structures, whether we have proper documentation. Earlier, it was only old people who have to be worried about this. Now it is not so. Youngsters also have to be very transparent in their managing their assets, wealth, properties, so that the other spouse and their children are aware as to what we need to do next. So one such thing is your will and settlement deed. It all revolves around the properties which an individual has. If any untoward incident happens, how to face the circumstances. So that is the idea behind this. So today, I will be presenting a small PPT so that you will have more clarity on that. We will be dealing mainly on settlement deeds, wills, release deed, and finally on the opinion as to which is better. If you see broadly the statutes governing these conveyances, the Transfer of Property Act, Indian Stamp Act, Karnataka Stamp Act, the Indian Succession Act, the Registration Act. So these are the few acts within the framework we have to operate, both for will and settlement and release deed also. I will be explaining you as to what is the will, what is the settlement deed, what is the release deed in detail going forward. Let's first talk about a settlement deed. What is a settlement deed? It is a legally binding contract that settles claims regarding disputes between parties. So, when a person is alive, if he is going to deal with his property and he is going to identify his beneficiaries and arrive at a settlement, it is called a settlement deed. So, during his livelihood, he himself can decide as to who will enjoy his property and how it can be distributed. And people need not wait till his death. Mostly, many people are possessive about their properties, very sensitive about their properties, and they don't have confidence in their children or grandchildren as to whether they will dispose of the property. That's why people till their last breath live in their self-acquired property. And mind you, this settlement deed and will is only about self-acquired property. And I am not discussing about ancestral properties at all, which is governed by the Succession Act, Indian Succession Act, which everybody is entitled to. It will devolve as per the family heirship and the courts will be involved in that. So next slide, please. In a settlement deed, you have settlor and claimant. Effective and efficient disposal of matter has been done. Alternative to litigation, deemed to be final document, can be declared invalid only by court decree. Mutual consent and agreement is very, very important in a settlement deed. Without mutual consent, a settlement deed cannot be arrived at. So, purpose should not be unlawful or illegal. Effective immediately. The moment the settlement deed is signed, it's effective. Cannot be cancelled unilaterally. Only with respect to self-acquired property, as I mentioned earlier, to be signed by all the parties to the deed. So this is the entire gambit of a settlement deed. So these are the nitty-gritties involved. If you see the whole thing, the settlor and the beneficiaries should be consenting, then only an agreement can be entered upon. If they are not in mutual consent, then this doesn't apply. That's why people write a will and die if they are not able to arrive a settlement during their lifetime. Next slide. So elements of settlement deed. Definitely a date should be there, name and details of the parties, recitals, key obligations, release of parties. Release is something I'll be discussing. Default actions. So this is very important. This default action is very important to protect the settlor. Subject matter is normally revolving around the properties. Even it could be jewel also. Next slide, please. Types of settlement deed. One is the conditional settlement deed. The settlor lays down conditions that the claimant is bound to follow. Non-fulfillment of conditions can make settlement void. Example, parents can add conditions like they should be allowed to stay with the children, taken good care of while making a settlement deed. Failure to fulfill these conditions can call upon for cancellation. So this is the weapon a person can have to jot down in the settlement deed that I should be taken care. And if the beneficiary fails, he can cancel it. So this is one very strong instrument and it is called a conditional settlement. The other one is the absolute settlement deed where there are no conditions. So you sign a settlement deed, the property becomes absolutely the owner of the beneficiary. So no condition explicitly mentioned by the settlor by which the claimant is bound. Property gets transferred without any beneficiary. So broadly, there are two types of settlement deed. One is the conditional and absolute. Absolute is nothing but you dispose of a property with a beneficiary and the property goes to the person. Conditional, you put a condition that I should be taken care, your wife should be taken care. All these conditions you can put so that you can cancel. The power of cancellation is with you. Next slide, please. Now we are coming to the release deed. There are situations where during a settlement, certain people may release their right or interest in the property. For example, there is a building, maybe the father wants to give it to the daughter. Brothers may say, no, okay, we will give it to the daughter. They might release. So, legal document removing previous claim or interest on an asset is done by a way of release deed, releasing rights over a particular asset. Release deed is considered valid only if it is registered. Even the settlement deed also should be registered. So by release deed, what we say is, supposing there are 4 beneficiaries, 2 say, okay, we will not be waive of our interest. We will write and release deed and give. It is something like NOC. The other beneficiaries will become the owners of the property. And of course, this release deed has to be registered, and I'll come later on the registration process. So now we have discussed about settlement deed, the release deed. Next, we will go to will. So what we were discussing earlier was during the lifespan of the settler. So he ensures that things are in place. He sees who's the absolute owner, who's the person who's going to take care of him. All those things he's doing through a settlement deed. There are occasions where, as I told you, people are so possessive and they don't want to give away the properties and they don't have faith over the beneficiaries. They write a will so that after their death, this will definitely give a way for the succession. So a will has to be written by the testator so that the beneficiaries can avail. So it is a legal document expressing a person's wish on how they want their property to be distributed after their death. Next slide, please. So who are the parties? You have testator on one side, beneficiaries, executors. So testator is the person who writes the will or whose will it is. Beneficiary, these people are the named in the will by the testator. Executor, the person whose responsibility it is to execute the wishes of the deceased contained in the will. Normally, an executor will be a close friend or any trustworthy person in the family or in his acquaintance whom the family also knows, who can be an influencer or a mentor to that family. That kind of a person normally they choose. It can be a very senior person or a very literate person. It depends upon the testator and the beneficiaries. More importantly, the beneficiaries should accept such an executor. You can't bring a third party. You can bring, but people should know about them. Next slide, please. So will is again a testamentary document, comes into effect only after death of the testator, only with respect to self-acquired property. Again, I'm saying this is self-acquired property. No specific format. You can write in any format. Normally, people go to a lawyer to draft it because they feel very comfortable. But in case you are in a remote place, you are not able to hire somebody, no specific format is required. You can just write in a simple language known to others, or even you can have it dictated by someone and write, put your signature. Intention of the testator given importance while dealing with the ambiguous wills. Should contain name and address of the testator. Revocable by testator upon creation of a new will, can include a statement declaring that you disown all earlier wills. See, normally people at older age, they feel very insecure and they start writing wills during a particular year and they survive for another 4 years, 5 years. By then, things may change. A new grandson would have born, a grandchild would have born, or um, um, uh, among the beneficiaries, there could be some, uh, people who have died. So accordingly, the wills keep changing. So the person writes a will subsequently. So the last will is the will which we have to consider. In case of two wills by the same testator, then the last will is to be considered, and there is a case law on this. And especially the wording should be that this is going to supersede all the earlier wills which I have drafted or written. So that's very important about the wills. Once a will is written, it should be registered, though it is optional under section 18 of the Registration Act. It is optional, but you have to register it. This is a very important point because the will, the registered will becomes a document which can be identified as the final will. Nobody can question it. Of course, they can dispute it. They can dispute it in any way, but a registered document is a better document than an unregistered document. So as an advocate, I would recommend you to register even before your death and keep this document in a safe custody in a bank, or keep it, give it to your executor so that he can bring that at an appropriate time. Next slide, please. So in a will, there is one or more executors appointed by the testator himself, and there should not be any ambiguity in the will. For example, you cannot say property not distributed should be properly, it can be distributed to anybody. So you should specifically mention, I leave the remainder of my estate to my daughter. And you should not give any ambiguity that, the residual assets can go to any of the beneficiaries. So you're giving room for a legal battle again. So let us be specific on this. Next. Now I will go to the types of will. Before that, I will mention who's capable of signing a will. He should be a sound person, a minor, not a minor, persons who are deaf or dumb or blind are not thereby incapacitated for making a will if they are able to know what they do by it. So a deaf and dumb can have a person or a lawyer to write the will as per their instruction. A person who is ordinarily insane may make a will during interval in which he is of sound mind, and that too there should be some witnesses around him so that people understand that he is there. No person can make a will while he is in such a state of mind, whether arising from intoxication or from illness or from any other cause, that he does not know what he is doing. So this is the basic requirement under the Indian Succession Act. Next slide. Coming to types of will, there are privileged wills and unprivileged will. So what is the privileged will? Wills made by any soldier or airman engaged in warfare, or mariner currently at sea, any medical officer on duty in an expedition, any naval officer at sea, written or oral. It can be even oral also. That's the catch here. And unprivileged, any person that does not come under the categories mentioned for privilege will can make an unprivileged will. So any ordinary citizen belongs to this category. Why this privilege will is given to them is they are normally soldiers, mariners, and medical officers are all duty bound, and if they are facing some uncertainty or insecurity, they can execute this privilege will, and Since the bill is registration is optional, they have this privilege, and their seniors can carry out this will as a testator, and it can be oral also. If it is recorded, nothing like that. Next slide, please. Written only by the testator by hand, need not be signed, attested. This is I'm talking about the privileged will. The soldiers and mariners, doctors, written wholly in partly by another person or signed by a testator, need not be attested. However, if not signed, deemed to be his will, if it is shown written by the testator's direction, recognize it as his will. The soldier, airman, mariner, many make a will by word of mouth by declaring his intentions before two witnesses present at the same time. Such a will be null and void at the expiration of 1 month if the testator has ceased to be entitled to make a privileged will. So this is a situation where if people find he has ceased to be a privilege, he's not in the job. For example, he was not a soldier or he has been suspended, so he can't. That is the way that classes come in. Next slide, please. So unprivileged wills are wills which the normal citizen signs. The testator will sign, affixes mark to the will. Placement of the same is important, intending to give effect to the writing as a will, attested by two or more witnesses, each of them who has seen the hello. Yeah, attested by two witnesses. The witness is important here because he is the one who can vouch that such a will has been executed by the testator. This arises only when somebody contests. That is why people who are signing the will should be at least known to people and should not be a third party like drivers or somebody in the register office. Normally people don't go with the proper witness and they just call somebody who's standing there, and if the will is contested you don't know who is the person and you can't trace them. That's why witnesses are very important who can come and say that yes, this person signed in front of me. So a will witnessed by an inheritor mentioned in the will or his spouse will be a valid. However, the property would not pass to the inheritor witnessing the same. So the inheritor who's inheriting the property cannot be a witness. It should be another person. That's the criteria. Next. When it comes to witness, who can be the witness? Of course, he should be a major, a sound mind, not expected to know every details of the contents of the will or settlement deed. Purpose to make sure who is signing the document. Always better to get a witness who personally knows the signatory. Next. So we are going to talk about the registration aspects. For a settlement deed and a release deed, if it is a family member, the cost is very less. It is only going to be a stamp duty of 1,000 rupees and registration fee of 500 rupees. But if it is going to be a third party, the Stamp Act is applicable. It is applicable on the market value of the property. This applicable rates right now it is 5%, and the registration fee should be 1% of the transaction. So any third party transactions in the settlement deed or a release deed, if it is not within the among the family members, the Karnataka Stamp Act will apply, and you have to pay the duty to the government. If it is within the family, the Stamp Act is very lenient about it. It's only going to cost you 1,500 rupees plus the advocate or any other expenses. So in case of will, there is no need for compulsory registration. This is because a testator is required to be present in the registrar office. Supposing he dies in the hospital or he dies in an accident, if his will is there, that is enough. Only thing is, it should not be contested. So registration is optional here. Advice to always, as an advocate and for any other purpose, the will should be registered because there could be a contest on that. Normally, a will is being registered with the sub-registrar of that particular area. No deadline for registration. It can be done even after execution. So the will can be signed today and it can be registered later also whenever the testator feels. Or he can amend the date also. It's not a problem because he's alive. So the stamp duty is nil there and the registration fee is around 200 or whatever it is. It depends upon the state to state. Again, here in the settlement deed and release deed, different states have different stands. In state of Karnataka, both the settlor and the settlee, releaser and the releasee have to be present for the registration purpose in front of the witness. In state of Tamil Nadu, when we did recently, only the settlor is enough or the releaser is enough. Releasee is not required. If he is around, the registrar will just check with him as to whether you are aware about the contents. So sometimes they may call in person, but they may not insist them to be party to the registration process. So with this, I think we have covered everything. And finally, I would like to conclude this session by mentioning who are the family members. Family members are father, mother, husband, wife, son, daughter, daughter-in-law, brothers, sisters, and grandchildren. So this is the family. If you can notice, brother-in-law is not there, son-in-law is not there in the list. So it becomes a third-party transaction and the stamp duty applies to son-in-law and brother-in-law. So this is the structure as defined under the Succession Act and Stamp Act also. The family members are defined. Next slide. So coming to the conclusion part is whether will or settlement deed, which would you prefer? If the parents have trust on their children, a settlement deed is a better bet so that he can execute a conditional settlement deed so that he's taken care of. At the same time, he is allowed to live, he or his wife, till his death, and he has the weapon to cancel it at any point of time. And he is also rest assured that there is no other disputes coming up. And settlement deed can also be changed at his own will. Even if he wants to change the settlement deed later on, he can change it with proper release deeds so that no confusion is there after his death. However, it is possible only if the parties consent to the same. In the settlement, the important element is consensus between the parties. So everybody have to accept. If there is at least one party doesn't accept, then that you cannot arrive at a settlement deed, and the person is forced to take the next option, which is will. Will invites huge possibilities for dispute and litigation with respect to its validity and other aspects. Therefore, settlement deeds are a better option while keeping the aspect of finality in mind. However, though settlement is better than will, but in case you are not able to arrive at a settlement deed, will has to be done. It's a compulsory, and I would suggest none of them to leave his assets without a will, especially the self-acquired property, because will definitely solve future litigations, and the beneficiaries and the successors can divide among themselves. It will be a guideline as to what the testator had intent. There are some people who contest, but let us ignore those. But a will really help even after death, so that the successors and the beneficiaries have no confusion and they can follow the will verbatim. And if a testator, if an executor is appointed, he will also influence it. So it is better to have a will in place. If a settlement is alive, nothing like that. So with this, I would suggest all of you, the participants who are here, also spread a word to others to keep their financials, property assets, the khatas, the papers, heirship certificate, all these things in place. It might be a strenuous thing, sir. There are a lot of people who purchase immovable properties like flat, but the builder's name, the khata will be still standing in the builder's name. Only when you go for a sale, you will get to know that it has not come to your name. In case you are not there, then the spouse or the children will be in trouble. This will take long process. Hence, please ensure that all the properties you own is in your name. And if you feel that you are not keeping well, please add a joint holder. All the bank accounts, please have a joint holder. Nominee is not sufficient. Nominee is only a person who can operate that bank, but it doesn't belong to him. So joint holder is better. If you have single bank accounts, please make your spouse a joint holder. This will be very, very handy, because after your death, everything becomes a problem. And there are banks, private banks, which is very, very, tough to prove that the spouse can enjoy that money. There were instant cases when the Carlton Tower got burnt. I had a client who came, wife couldn't operate the bank account, and the account had more than 25 lakhs of money in the bank, but she couldn't operate. She was penniless until the bank had suggested them to get a succession order from the court. So it is another 6 months' time. Till then, she had to borrow and live. See the situation. A simple joint holding account could have saved a lot. So please, all of you ensure that accounts are having joint holders, at least nomination, to ensure that after your death or any untoward incident. Today, situations are bad. We don't know who will survive, what will happen. So these are all in our hands. That's why I brought this topic in this moment. Now we are talking about the fourth wave coming up. So let's be prepared. Mask will not help you to protect your succession plan. So please ensure that things are in place. Little bit of meticulousness is required in this to keep everything in proper. If you see, our elders have done that. They are very meticulous. They go to the bank and get the pass written, passbook written. They're updated. Today we don't know our balance also. He will tell you immediately how much is my balance, but we don't know. We have to check. We'll forget our password also. So this is the situation when you have multiple bank accounts. Which bank account, what password? How will your spouse after your death identify all these things? What is she going to do? She will only curse you. So save that. Ensure your succession plan, and see that after your death also people respect you. So with this, I think I have completed this session. Any doubts, questions? Floor is open.
The participants can unmute their audio and ask the questions.
Continue straight onto Lalmag Fort Road.
Dr. Om, it was an excellent session and very informative and very brief. Om, I have a question.
Yes.
Like if the properties are situated in different states, what is the process to be adopted?
Same, sir.
In the
Different
in the
states.
case of will.
Will, yeah. See, you can write the will and mention the document, the properties and the state, everything you can mention in the will. See, in the will, actually, the properties will be disclosed. This property in this state belongs to so and so. I'm going to give it in so and so place. What is your question actually?
No, see, the issue which it came to my knowledge is, like, suppose we have registered a will in the Karnataka. Some of the properties are in, say, example, in Tamil Nadu. The Tamil Nadu is registrar is insisting, like, no, it has to come through sub-registrar and they have to send it and they have to record it there and then they have to take it or something else.
I think I have not faced such an issue, but yeah, some sub-registrars, they insist on this because that is why the witness is very important.
Must be talking about a succession order,
Succession order.
not a will.
So there you are talking about a probate, sir. You have to get an
I
order
think
from the
probate.
court. Probate, yeah. That is what they are talking about, sir. See, when it goes different borders of the state, you will need a letter of probate from the court. That we have to apply. That is why I was saying settlement deed is better than will.
I think it was not a will, it was a settlement between the brothers. They registered in Karnataka and the one property was situated in Tamil Nadu. It's not a valid one and it's a Tamil Nadu again.
If the registrar is going to insist on that, we need to see the legal stand on that, because once it is registered, there is no point in asking for a probate on this, because the settler is there.
No, I think let me rephrase it as slightly different. Just a minute, please. I think what we must be talking about is talking about a settlement deed where the property is situated in multiple states.
Multiple states.
Okay, now you said registration is dependent on a percentage of the market value. Now, if the property is is situated in Tamil Nadu, in this case which he said, the Karnataka government state is enjoying the stamp duty and registration cost for a property which is lying outside the state. So when you try to execute it in Tamil Nadu, the government is likely to say that I have not seen that revenue or settlement in my favor.
Yeah.
So in that case, maybe
the settlement deed, the settlement deed at that stage itself, we have to register in 2 states.
Correct.
Yes, sir. Yes, sir. See, settlement deeds are different from will. In settlement, each state, wherever the property is getting settled,
Exactly, yeah.
that state you go and register. For example, Om was explaining about the stamp duty registration cost. If my memory is correct, I think recently we did one. 25,000 is the registration fees in Tamil Nadu for settlement amongst the family members. And in one case we did was give it to the daughter and daughter to son-in-law. So the 2 settlements we did, still it was only very small amount. So that we are bringing under the family members category.
And it goes with the property situation. If the immovable property is situated in a different state, it is better to have the settlement deed registered in that state for that particular property.
Yeah, it should be done there only.
In 500 meters, turn right after Coaching.
Otherwise, this confusion will always come.
And that is not the requirement in relation to will. Will is registered if it is required to be registered, of course. There, wherever you are there, you can register it. It's not at all a problem. Property could be outside the country also.
Okay. Thank you, sir. Thank you.
Next
And
question.
in some states, sir, probate is mandatory. For executing the will, in some states,
Yeah, probate is
probate is mandatory. It is not mandatory in Tamil Nadu.
Okay, sir.
Next question.
Morning, Om Prakash, Madhusudan BD here.
Morning.
In case of my client has lost the will itself, original will is misplaced or not traceable, only the Xerox copy is there, photocopy. Will the court accept that? Witnesses are there, both will, two witnesses, both will come, but only Xerox copy, photocopy.
Witnesses are there?
Yes, definitely, both two witnesses are there.
And their signatures are matching to those where they have signed?
Yes, definitely.
No, the court can accept it because the witnesses are there.
Okay.
Because that is why though the original document is not there, how did they get the photocopy? He had given
Somewhere
to
they
some
have
other.
traced. Yeah, on
And
the
is there any
computer,
executor in that? Executor is there in that will?
executor not written.
Okay. But it should not be a problem, sir, because witnesses are there.
Yes,
So,
witnesses are very much there.
so we can really, with that, we can go ahead with that.
Okay, thank you.
Good morning, sir. This is Ravi Kumar. Very excellent session, sir. This one is very informative. My question is related to will. It says that self-acquired properties only need to be willed. What about unsettled succession properties?
So that is as per the Hindu Succession Act, sir. We have to go by that. The Succession Act will take care of it. Will is only in respect of your properties where you have the say. Ancestral property, the law takes its course. So it goes by the Succession Act. Who are all destined to acquire that property, who are alive. So maybe you can give a clarity on that, and it goes by the family heirship certificate.
Whether we can insert one term in the will saying that in case of the ancestor property is succession, then the share of the testator can mention the share of the property for the unsettled one. Whether we can mention one term in the will.
You can mention in that this property is an ancestral property, and it will be determined as per the Succession Act or whatever it is. But if you have got a partition in your name through
Right, sir.
the partition deed, if the testator has got in his name, again that can be claimed by the successors. So you don't have a say on that.
Okay.
Or if people are if the beneficiaries are willing to execute a release deed, then you have a say.
Okay. Yeah, thank you, sir.
Thank you. Who else?
The benefit of the audience, the effect of 99/2005 amendment was very nicely discussed and decided by Supreme Court in Vinita Sharma versus Rakesh Sharma.
Correct.
9/9/2005. This is the one judgment which is clarifying. Of course, the focus was on daughters and whether married daughter, unmarried daughter, all these questions were raised previously across the country in various courts. After the amendment and after this decision of 2020 Supreme Court Vinita Sharma versus Rakesh Sharma, it was clarified that married or unmarried before 9/9 or after 9/9, if partition has not taken place, the property ancestral will go to everybody. And therefore, as Dr. Om Prakash has rightly said, the question is to whom it gets going, that is decided by the act. If your portion is there and you want to write in the will that my portion will go to so and so, that is also possible. So, but that depends originally from the Hindu Succession Act amended by the 9/9/2005. That's all, sir. I'm just adding one clarification.
Thanks, doctor. Thanks, doctor.
There is one question from Mr. Vineet Verma. How does transfer of property and personal assets work in case a person has died without leaving a will?
Died without?
Leaving a will.
Sir, here this question, it should be settled among the beneficiaries. If it is ancestral property, then it should be shared according to the law. If it is self-acquired property, of course, if the mother is alive, then it goes to her. And there is a succession plan also as per the Hindu Succession Act as to who can, intestate succeed the properties. So accordingly, it can be, shared or distributed. Normally, the spouse and the children will be, including the daughters, will have equal shares. And if somebody is willing to, disclaim or release it, he can give a release deed. The balance people can enjoy that, or it can be settled. So it should be, sat across and decided. But according to the law, the survivor, the spouse, and the children will be the succeeders of the self-acquired property. Hope I have
Thank you.
clarified.
Thank you so much. Thank you, Om.
Any other question? Thanks all of you for, on a Friday morning, that too at 10:45, and a quick short notice, all of you have come and attended this. Thank you very much for this opportunity. This committee will come up with such practical issues which we are facing, and not, if we don't do certain things, we get caught unaware. So we'll bring such topics. You can also recommend a few topics so that we can work on that. If there are no other questions for Madam, any other questions? So thank you all for joining this session, and we will catch up in the next special talk, which will shortly be announcing. Thank you very much.
Thank you very much, Dr. Om Prakash, for this exhaustive session. Thank you once again, sir.
Thank you, sir.